those kinds of specifics for now. I think as long as I've highlighted the areas of concern, and by the way, some of these are raised in the general statement, in the main body of the statement, not the Q&A part. Thank you. I'm indebted to the Commission for the indulgence. Thank you.
Thank you, Mr. Mpofu. Yes, Mr. Law.
Thank you, Chair. Chair, I perhaps will not address every issue raised by Mr. Mpofu for two reasons. One, some of these issues will be elaborated upon by the General himself because they form part of his statement. So perhaps that might be at the appropriate time to engage with them. But secondly, because to some extent, Mr. Mpofu takes issue with the processes of the Commission and the relevance of what the Commission is pursuing insofar as this particular witness is concerned. I can put up an argument as to why we consider the witness relevant, but perhaps as a general point, that would be best placed with the commissioners to engage with. So if I don't address everything, I want to effectively put on record that it's not due to a lack of answer on my part, but I choose to limit my answer on the two bases. However, there are certain things that I believe I must address because this would be strictly within the knowledge of the evidence leaders and not necessarily the commissioners. The first complaint is a serial refusal to produce documents. I would like to place on record that the General, even in his statement, does not make such an allegation. There is not a single document that the evidence leaders have been required to produce and have failed to produce. To the extent that there might be oversight on my part personally on that, I would be happy to be directed there too, and I'll try and establish why that is the case. The only issue that the General raises in his supplementary statement are documents relating to the testimony, I think of, I'll get the ranks wrong, I apologize, it's Colonel Prinsloo and another. And he claims these were provided to him 2 days before his statement was due. When General Senona's appearance was postponed the last time, these issues were specifically dealt with when my learned friend, Ms. Talk, addressed the Commission. And it was highlighted that precisely those documents were provided on the basis of a request from General Senona. The request came in that week, and by the 29th, the documents were provided. So it becomes challenging for me to appreciate exactly which documents we are said to have refused to produce on a serial basis. And commissioners, I dare say that there is none. Secondly, and once again, General Senona will address these issues. I do know that Mr. Mpofu says they appreciate the distinction between what we would term a Rule 3.5 notice and a Regulation 10.6. But my understanding of, and I put this in inverted commas, of his, and by his I mean the expanded definition, plural, complaints seems to blur the distinction between the two. If one has regard to General Senona's statement, his complaints stem largely from a view that we have failed to serve him with a Rule 3.5 notices. And these are notices that we issue based on testimony that is received and evidenced by the Commission on the basis of which we conclude that it would appear somebody is implicated. The witnesses he references, in our understanding, and I do accept that our understanding may very well have been wrong, have not implicated General Senona. Those witnesses have testified to what they know about the facts that they were called upon to testify on. There may be a difference in response to the same question, in that General Senona would have given a different response. But that does not in itself imply that he's implicated. So technically, it would sound like, and again, I'm subject to correction, that there is an invitation that we issue Rule 3.5 notices, because each time General Senona's name is mentioned by the witnesses who have appeared before you, that constitutes implication. Not in our view, not in the manner that that term is dealt with in the rules. Once a witness is implicated, we are under obligation to issue a Rule 3.5 to bring that to their attention and to afford that person the opportunity to deal with the implication. We have found none, and no Rule 3.5 notices have been issued. What instead has been issued is a Regulation 10.6, which, once again, is a document that is generated a specific person may be able to shed more light. In that context, specific questions are posed to the potential witness, and they are invited to answer. So it becomes a challenge when we are confronted with an allegation that we do not afford witnesses, in particular General Senona, the right of reply. His right of reply, as I understand, would arise where he's implicated. Where he is not implicated, his right of reply does not arise. In any event, on a proper reading of the rules, any witness who believes that they may be of assistance to the Commission, either by providing a contrary position or testimony, is entitled to make application. So to the extent that it is considered that we have failed to issue Rule 3.5 notices, which I contend it's not correct, none was due to General Senona on our assessment, then it was still open to General Senona and his team to apply, to testify on those matters. Thirdly, and most importantly, notwithstanding the fact that General Senona has specified which witnesses implicated him, one, in his supplementary statement, he has failed to articulate that implication, the extent thereof. And secondly, has failed to take opportunity to deal with that which he considers to be an implication. Now, I understand, and I think we all do, the basic legal principle of everyone's right to face their accusers. I'm just at a loss with who in this context are the accusers. There are no accusers to General Senona. Lastly, it is important to bear in mind that General Senona was scheduled to appear on the 8th of May, 2026. He was part of the DPCI KZN management. From the management of Port Shepstone, DPCI, Colonel Prinsloo and them, to Brigadier Newswa, his direct reportee, and eventually himself, the one person who's responsible for DPCI KZN. That was the stream that was scheduled to start from on the 8th. Together with that were the people who were involved in the actual seizure and subsequent storage of the drugs. We are here today on the 19th of June, 6 weeks later, in part, due to General Senona's own application to postpone his testimony, firstly from the 8th of May, up until the 1st of June. He presented himself on the 1st of June. Due to the Commission's own scheduling challenges, he had to be stood down to the 5th of June. Came the 5th of June, we accepted that his legal representative was indisposed, and there was a further extension. So the 6 counts of appearance don't seem to tally with my record. The request that he come only after everybody has testified on the Port Shepstone drug bust presupposes that those witnesses implicate him. And there is no fact that even points to that. He was never intended to be engaged on the matter as an implicated person. The thinking has always been to engage him as head of DPCI KZN, who I assume, perhaps wrongly, at the end of the day would accept that the buck stops with him. So the toing and froing of correspondence has always been to try and clarify this challenge, why General Senona believes that he can only offer his version of the events and the questions posed after everybody has spoken. There are rules, as I read them, and the regulations do not allow for that. And it is in that context that the response eventually to his attorneys was that they need not worry about what others would potentially say. He is required to address himself to the questions posed both in the Regulation 10.6 and the subpoena, to the extent that he is able to do so. Should another witness come forward after he has testified to contradict him, then that is for the Commission to engage with and to determine whose version is acceptable and on what basis. I don't know how other commissioners intend to deal with this, but to the extent that I properly understood, my colleague, Mr. Mpofu, sounds like he wants assurances that there will be no straying outside the subpoena. I don't know what that means, but I can assure him that subpoenas are issued, Regulation 10.6s are issued, and in the course of engagement with the witnesses, there are issues that arise from the question and answer session. And for lack of a better term, I'll call them offshoots. And I don't know if it is the offshoots that he would deem constitute straying outside the subpoena, but that just might be an issue with my, my understanding. Did the General speak to some of these matters at his previous appearance in January 2026? Yes, he did, and we are truly aware of that. However, since his appearance in 2026, the Commission has been placed in possession of significant documents that are relevant to the issue. Other witnesses have testified and too produced documents before the Commission. And as the head of the KZN DPCI, we believe that it is necessary to engage him based on what has since come to light. I don't see that to be a challenge, and it doesn't, as far as I'm concerned, constitute toing and froing. It is assisting this Commission to arrive at a correct factual position as regards matters that fall within its terms of reference. The relevance, we maintain that they are relevant. The rules and the regulations tell us so. At the risk of stating the obvious, amongst other things, what this Commission is mandated to interrogate is whether criminal syndicates, including but not limited to drug cartels, have infiltrated or exerted undue influence over a range of entities, including the SAPs, of which the DPCI is a part. And then to consider the adequacy of current legislation, policies, and institutional arrangements in preventing such infiltration, and then to make recommendations where necessary. I don't understand the contention that where he admits he did not follow prescripts, that is where the issue must die for purposes of the terms of reference for this Commission.
The one I had in mind, Ms. Sello, was 3, which says the role of senior SAPS members in aiding or abetting criminal activity, either through act or omission.
I fully agree, and Commissioner Kumalo, thank you. So the challenge I have is what comes across as a position that says, notwithstanding the wording and the wording of the terms of right, the purpose of the Commission, that the head of the institution that was responsible for precisely these drugs cannot be engaged more than once and cannot render assistance to this Commission and if I recall, our rules require that a witness becomes available and answers the questions to the satisfaction of the commission. To the extent that the commissioners remain unsatisfied, I submit that it is the commissioners are entitled to recall a witness to assist them in determining the correct factual position. I do not believe, as Mr. Mpofu suggests, that this commission is attempting, as he says, to be a surrogate disciplinary process or committee of the police. On the contrary, and particularly on the basis that Commissioner Khumalo highlights, the role of senior officials in SAPS, including KZN, remains a pivotal question before this commission and must be answered. And the only person who can answer precisely those questions are those who are deemed to be senior officials within SAPS. It's not a performance assessment, but there will be interrogation about the knowledge, the application, and approval of conduct by the head of the KZN DPCI of members that resort under his authority. And that engagement must be had to understand, as my learned friend correctly pointed out, whether it was, he says, whether it's incompetence or it's deliberate. To answer that question, we must first understand what the understanding was, the appreciation for applicable prescripts and the like, to enable the commissioners to make a determination as to exactly what transpired. An interesting point was made by Mr. Mpofu, where he states that it is unnecessary to recall the general, particularly where he admits that he didn't follow prescripts. I'm not aware of such an admission. I'm not aware of him so admitting in his first statement, during his first appearance in January, in the supplementary statement, nor in the responses to Regulation 10.6. I see Mr. Mpofu vigorously shaking his head, so I take it that he means I completely misunderstood him. I'll take that the misunderstanding is mine. But I just wanted to clarify that precisely what the prescripts provide for and the extent to which they were complied is a legitimate conversation to have with the General, and that has not to date been had. Thank you, Chair.